Thank you very much, Professor Bedi. I would like to thank everybody for attending this conference today, this lecture, and I must say there are common grounds with the presentation given by Professor Bedi that I will address. Some differences as well, but some commonalities, some things that are common. So I just would like first to share my screen so you can see my PowerPoint. Do you guys see it?
Yes, sir.
Okay.
Yes, we can see it. Yeah.
Fantastic. So first of all, I just need to do a little disclaimer. So everything that I will say is not binding on my work as a prosecutor for the Public Prosecution Service of Canada. Everything I say today, it's only on my behalf. So let's move on to my part of this presentation. But like Dr. Bedi said, and I will just move on to the first slide here, the right to life. And this is quite interesting there. And the right to, does it include the right to die? And the Supreme Court of Canada, it's not in the slide here, but basically Dr. Bedi wisely and brilliantly covered the issues that basically COVID-19 changed our lives. So I would like to jump directly to the issue of the treatment of people basically who are either wishing to die with dignity, not wishing, but you never wish to die, but who should die with dignity. So there are several decisions. This issue has been addressed by the Supreme Court of Canada in the past, not, of course, in the context of COVID-19. The Supreme Court of Canada changed his mind, if I may say it this way, but assisted suicide, and I will make a connection here, of course, but basically what the Supreme Court of Canada is as well, the right to life should include the right to die with dignity. And not that the Supreme Court said otherwise in the past. However, in terms of being given an assistance to die, it was denied in the decision Rodriguez several years ago, but more recently in 2015 in the decision, the Queen versus Carter, C-A-R-T-E-R, the court revisited this issue and decided differently. But what's more importantly, and that's been raised by Justice Deschamps and the Queen versus Shawley, so right to life does include to be treated with dignity. And nowadays it becomes really important. So what I will discuss today is that there are clear connections that you will see with what happens in India. And I'm very happy to discuss it here. So basically the impacts on fundamental rights provided by the Canadian Charter of Rights and Freedoms, which is the legal instrument that provides for fundamental rights in Canada. So I will move on directly to the third slide. Dr. Bedi wisely addressed the impact of how COVID-19 changed our life with respect to everything, basically, right? The only thing I would like to mention with this slide here is that this issue was acknowledged by the court in Canada, by several courts, obviously, but this is the best description of the phenomenon, in my opinion, that encapsulates what happens in the world nowadays. So in the decision of McConnell here. What is interesting in Canada, that's the biggest connection, in my opinion, with India, as described by Professor Bedi earlier. In Canada, there is no state of emergency per se that were declared in Canada. There are states of emergencies that are declared by the provinces. We do have 10 provinces, basically subdivisions in Canada, 10 provinces and 3 territories. All of them declared a state of emergency, but basically Canada, even though as a country is in the position of a clear emergency, there is an act that was not relied upon by the Prime Minister, Justin Trudeau. So, as it was described by Dr. Bedi, Professor Bedi earlier, so there is even the government chose a different path. So there's in Canada what's called the Emergencies Act. It basically does include disasters, epidemics like the one, pandemics like the one we are currently experiencing under Section 5. So the government did not rely on it because it's not applicable. It is totally applicable. But the government chose instead to use other legal instruments which are less impactful, including impactful on fundamental rights. So the government chose to rely, for example, on a Quarantine Act to mandatorily oblige people to stay at home, and various other acts that are showing on the slide right now. And why so? Well, I don't know. I'm not in the mind of the Prime Minister, obviously. But the Emergencies Act, one of its most forceful or most serious impact is the suspension of human rights that is possible. So basically, even though there's the scrutiny of the court, the government, the executive, it could be entitled to basically suspend rights and freedoms in Canada. And what you need to know to provide a short historical background is rights and freedoms were suspended once, well, besides the wars, but in normal times, even though COVID-19 is not a normal time, but before, besides the wars, the world wars that Canada also was involved in, it happened, the suspension of rights and freedoms, in October 1970. There was the October crisis because of a separatist movement of one of the provinces in Canada. That province is Quebec, mostly French-speaking as opposed to the rest of the country, which speaks mostly English. That issue is a bit more complicated, but summarily, a few members of a terrorist group called the Front de Libération du Québec, or Quebec Liberation Front, committed terrorist acts again, and then the government decided to suspend, to apply the War Measures Act. The War Measures Act is basically the act that existed before the Emergencies Act, but in short, it is very similar. So why do I talk about this? It doesn't seem to be connected. There is a clear connection here, and here it is. The actual Prime Minister, Justin Trudeau, is the son of the former Prime Minister of Canada, Pierre Elliott Trudeau, who was the Prime Minister who decided in 1970 to rely on the war measures, which basically suspended the existence, not the existence, but suspended the exercise of fundamental rights and freedoms. So and that caused at the time a trauma on, in terms of democracy, legitimacy. It didn't go well, of course, in terms of how rights and freedoms are really can be suspended just by relying on an act and everything, but from the government. So of course it leaves trace. I'm not saying that the actual Prime Minister necessarily had this in mind, but I find quite interesting that the actual Prime Minister did not decide to rely on this act. That would have been the easiest way. Say, we do rely on Emergencies Act, and that act would allow the government to, between quotes, force people to, like, for example, to force doctors, to force nurses, to force qualified people to work to help the population. But the government decided to go differently and decided to go in a smoother, in a nicer fashion, relying on the various other acts, but not the Emergencies Act, and which was said to be, and that's in the slide here, the Prime Minister Justin Trudeau said that until we have exhausted all other steps. So it's a last resort thing to rely on the Emergencies Act. So this is something that is common, not the historical background, obviously, but the fact that instead of declaring a state of emergency, of relying on the relevant acts or something, the government decided to go a different way in order to deal with the COVID-19 crisis. And what is interesting from a philosophy of constitutional law, should I qualify it this way, is what is stated by Oren Gross and also by Clement Fadovic. So like, basically emergencies, and this is great food for thought. I will address more specific rights later, but I would like us to focus on this for now, for a few minutes. Like times of crisis, yes, it does pose the greatest and most serious danger to constitutional freedoms and principles. Okay, fair enough, but why? There's a trade somehow, or in the social contract, to speak in terms of the French philosopher Jean-Jacques Rousseau, there's some kind of a trade and say, okay, for the security, on one side, for the security of our life, for our safety, citizens may be inclined to accept, okay, we will accept the suspension of our fundamental rights at the other end. But fundamental rights are a fundamental freedom, obviously, and this is one of the most important things that ensures that we do live in a democracy. So there is this trade between the citizens on one side saying we want to be healthy, we want to be alive and safe in one hand, and in the other hand, there's this the existence or challenges posed to the preservation of fundamental freedoms and principles that are traded basically and say, okay. And as Dr. Bedi recalled, which was said by the United Nations Secretary General, that shouldn't be a pretext, this crisis, to suspend or to trade, to say it in my own terms, to trade fundamental freedoms and say we'll suspend it, but in exchange, we'll give you safety. So this is, there are other ways. And what is interesting to keep in mind and to think about, maybe you would like to write about it in a paper at the university, but this is not the only way to preserve the life of every citizen. It's not, the only way is not to suspend constitutional rights. And Canada did that, and India did that with failures and successes in both countries. This is not the topic today, but you see that there is a more important core issue that is raised by this that speaks to the heart of our society's principles. And this, what I just talked about, is encapsulated by Clement Fadovic. He wrote, in cases of emergency, this vital principle, the principles of fundamental rights and freedoms, is also to readily sacrificed for the sake of public safety, national security, or some other overriding interests. So you see, citizens should not necessarily, maybe that this is what they would choose, and it's okay if it's democratically decided, fair enough. But fear should not be used by governments to rule and govern in a state that complies with the rule of law. So, and unfortunately, oftentimes it happens. Governments use it. So just to give you a quick summary of, because I will talk more specifically about specific rights and the impact of COVID-19 on those specific fundamental rights in Canada. So the Canadian Charter of Rights and Freedom was enacted in 1982 in Canada, following the repatriation of the Constitution in Canada. And I saw a question earlier about the doctrine of proportionality that I'm very interested about, but that's something else for later today. But this is basically the legal instruments, and as opposed, that's a distinction from India. India has a very long, if not the longest, constitution in the world. There are plenty of details. Canada's constitution is a bit shorter, not as short as the constitution of Indonesia, which was amended, et cetera, by various tools, but Canada is basically in the middle. The Canadian Charter of Rights provides for fundamental rights, and the Supreme Court of Canada is the last resort court where those principles are discussed and decided. So among those rights, there's the freedom of association. There's a decree that was basically, we all know that, and so that may seem to be old news now, but we were forced to be confined at home. But what about, and then we cannot gather together, and that was also the case in everywhere in Canada. This is something that was decided by each province. So that's why you see in this slide, the government of the province of Quebec forbade people to get together, but that applies in all provinces in Canada, which any gatherings were basically forbidden by the government of the provinces. So we will not enter into the division of powers issue. That's a different topic. But what is interesting for today is that there is the constitutional fundamental right of the freedom of association that usually is used in the context of demonstrations, of work relations. So people have the right to demonstrate, to oppose, to get together, to show, to express their other fundamental freedom, which is the freedom of expression. But here, the citizens were told to stay at home. So from the get-go, and we'll see it summarily later, there's the last slide. I don't want to go directly there, but I need to say it now for you to understand. So even though there could be a breach of the freedom of expression, I don't say that there is, but that there could be eventually a breach of the freedom of association by restricting the number of people gathering together, limit the number of people, or simply prevent people from getting together or arrest them if they get together. That governmental measure could breach potentially the section 2D of the Canadian Charter of Rights. But then there's the analysis in the Canadian constitutional law is a two-step approach. So, and let me know, I will move it there because that's important, and then I will resume to the other rights, but this is something that is fundamental for you to understand at this point. So there's the second step. If there is a breach, the analysis is not over. So it doesn't mean that the government measure will be simply told that it isn't not constitutional, etc. The second step of the analysis goes to the analysis of whether the governmental measure complies or is a reasonable limit prescribed by law, and that can be justified in a free and democratic society. So if the restriction to the fundamental right, and there's a more complex test, there are several subdivisions, sub-features to that test, but to keep it at the big picture level, the reasonable limit. So is it reasonable for the government to restrict the freedom of association, with the first example I gave you, in a free and democratic society? The government may say, I don't say that the government will say, but the government could say, well, we had to do it. Why? And that brings us back to the issue that Dr. Bedi addressed and I addressed, as well as the issue of security, of safety. So for the sake of safety, for the sake of health of its citizens, the government could say, well, yes, we did restrict, we did breach a constitutional right, but that was for the safety and the health of all of our citizens. Then we submit that this breach, even though that there is, if there is justified in a free and democratic society. And this is provided by Section 1. So Section 1, basically, it's all whatever the right, the fundamental right you talk about, and we'll see other rights today. But if there is a breach acknowledged, recognized as such by courts, then you have to go to the analysis of Section 1. So please keep that in mind. The other right, which is also obvious in terms of that is impacted by COVID-19 greatly is the freedom of movement. So I have an example here, and that's a practical example. One of the first cases was filed by a citizen of Nova Scotia, a lady who wanted to visit, or not to visit, but actually to go to another province, leaving the province of Nova Scotia and go during the crisis to Newfoundland because her mother passed away. She died, and her mother lives in Newfoundland, which is another province. She was told and she was stopped. She couldn't go. She said, no, you cannot go because we have restrictions of movement, so you cannot be there for the funeral of your mom. As it goes without saying, that lady was very upset, and then there's a case that is now filed in the courts challenging several articles, several sections of the Canadian Charter of Rights and Freedom, including the freedom of movement. Besides the issue of the division of powers, can a province decide to restrict the movement of someone, the Supreme Court of Canada acknowledged clearly and based on international law that is cited in the slide here. So basically everybody in Canada, as in India, everybody has in normal times, if I may qualify this way, everybody has to move, has the right to have the liberty of movement, to go, basically to go everywhere they want to go. If they want to choose to go there, they can. And the same if they want to leave the country, also that's also recognized. So that this is clear. But what is interesting here, the exception, and that's in the video of the Supreme Court of Canada 7 years before this year. But what the Supreme Court pointed out, and number 3 of the Article 12 of the ICCPR, which is an international law instrument on which the Supreme Court relied upon, is that the freedom of movement should not be subject to any restrictions, as I said, but unless it is necessary to protect, and I put it in red, public health. So it could eventually be justified, the freedom of movement, based on the necessity to protect public health, which potentially, given the circumstances here, could even be extended to almost an issue of national security, not as understood normally, but that's an extension that could be possible, and even to public order for various reasons. So you see that there's this here, that this balance, or this balancing of right that is triggered by COVID-19. And I'm sure that the Supreme Court of Canada, positive, in 2013 didn't even think that Canada would ever experience such a pandemic. But this rationale, this trade that I was talking earlier in the presentation, this trade between, okay, security, safety and our health on one side, and fundamental rights and freedoms, this is a balancing exercise that is difficult. And again, it shouldn't be a pretext, as pointed out by the United Nations General Secretary, to simply take it as a pretext to restrict all rights and basically turn democracy into a dictatorship. Another right that's impacted by COVID-19, and I will talk about it briefly because Professor Bedi discussed it very extensively and wisely before, but we do have this in Canada. The same issues are raised. There was, for example, the installation of geolocation, of GPS, as it's commonly called, but geolocation systems on cell phones with people who are diagnosed with COVID-19, that basically people around would be warned, it was not adopted, but still that was discussed. And this is scary in terms of potential breaches of the Charter of Rights. Section 8 protects against the right to be subject to a search that is unreasonable. And basically, if you install something on your own cell phone, if the government decides, okay, you are diagnosed with COVID-19, we will install a device on your cell phone that basically will follow you and advise and warn people around you and that you are diagnosed with COVID-19. So it may be seriously considered as a breach of Section 8. Again, and that was a perfect example. I used it to explain it. I used the example of India to explain it to a few of my friends who are not lawyers. That makes people, and that if there's one thing that was important, but there is way more that Professor Bedi said this morning, but that makes people like untouchables. And in Canada, of course, you have to explain what the category of people of untouchables are, but this is that speaks volume, this example. It turns people into untouchables. So basically, everybody around you will be warned, oh, you're affected by COVID-19, et cetera, et cetera. So this is an excessive intrusion in your privacy. So the right to privacy is also protected. That's included in that Section 8 of the Canadian Charter of Rights and Freedom. Now moving on a more procedural, not procedural, I'm sorry, but a more practical impact of COVID-19 on the courts is the delays are constitutionally addressed. I'm sorry? Oh, okay. The delays of the court system are addressed by the Canadian Charter of Rights. So basically, in the decision of Jordan in 2016, the Supreme Court of Canada said, okay, it takes too much time for trials, for hearings to proceed. That needs to stop. People they cannot wait for years and years and years before their case goes to court, like with all the impacts that they suffer, et cetera, et cetera. So the Supreme Court put a ceiling within which the trials or hearings must proceed. So Superior Court hearings, the ceiling is 30 months, and for a lower court, for provincial court matters, it's a ceiling of 18 months. What does it mean practically? Practically, it means that if the case goes beyond these ceilings, if it takes more time, well, the case may be stayed by the court. The court may, not necessarily will, there are exceptions, may decide, okay, that takes too much time. So this case, that will be stopped by the court because the prosecution took too much time to bring the case to trial. And it's a bit more complicated in terms of the calculation of delays. However, we're not gonna enter into this morning. But what needs to be pointed out with COVID-19 is that there's a delay. Courts have shut down for a substantial period of time. They start to reopen in Canada. I don't know how it is in India. I understand that the Supreme Court of India deals with urgent matters, but nothing else. I may be wrong, but I'm happy to be corrected on this. But courts in Canada basically reduced seriously their operations, and no trials until very recently were run. So that caused a delay. So what's the impact on COVID-19? But thankfully, there's one defense counsel who said, well, there are exceptions. When it's called the discrete and exceptional events exception. I use the terminology of the Supreme Court. So when there's an exceptional event that happens, that may basically bypass or justify the extension of the delay. So a case from the prosecution would not be stopped or stayed, said differently. So COVID-19 is obviously, in my opinion, of course, but is likely to be considered to be an exceptional event. It's an obvious statement. I'm just careful because I'm a prosecutor, but from a factual point of view, it is obviously an exceptional event. So these delays that could have seriously stopped many cases, and we're talking about serious, it's all cases. There are a few murder cases before COVID-19 that were stopped because the prosecution took too much time. So basically what it means is that the accused was released free. Doesn't mean he was guilty, but still, you see the impact of ceilings, of delays, which were augmented, increased by COVID-19, but thankfully, it is likely to be considered as an exceptional event. in terms of suspension of rights, what is interesting, and that I know for a fact doesn't exist in India, there's section 33 of the Canadian Charter of Rights. So after these few examples of the freedom of association, the fundamental freedom of movement, the delays, which is also addressed constitutionally, still the right to be tried within a reasonable time, provided by section 11B of the Charter. So basically, the legislation, the government can say, not can say, but when enacting an act, can provide specifically the non-compliance with fundamental rights. But this is provided by section 33. But in terms of checks and balance, which was also mentioned by Professor Bedi earlier, okay, but why Canada is not a dictatorship? Why? Because basically the government can say in every law, we will not comply with the fundamental rights, and we will use section 33, and we don't care about fundamental rights. Well, it's not that simple. So it is rarely, very, very rare that section 33 is relied upon, because basically suspending fundamental rights is rarely seen by the voters to be a good thing. So that's not the only explanation. It's one of many, several more complex explanations, but practically speaking, if a government would be relying on this on and on every time, of course, there's the ballot check at the time of the vote. So if a government does not comply with the Charter of Rights most of the time, there's a high risk that the population would severely vote against the government. So it is usually used in exceptional moments. However, here, the author, Maxime Saint-Hilaire, who's also a friend, we clerked together the Supreme Court of Canada, he wrote an article, very interesting article, where basically says that he found quite interesting that the Quebec legislature, so that's one of the provinces, but they did rely on, they did suspend the constitutional rights with the law, the act respecting the laicity or secularism. So basically, that law, in very brief terms, was telling people that they cannot wear religious, some persons of authorities, like judges, teachers, they cannot wear symbols that show their religious faith. And the government of Quebec used section 33 and say, we do know it goes against the freedom of religion, which is also constitutionally protected by section 2A of the Charter of Rights, but we do rely on section 33 and we do suspend it. So they used it in 2019. But even though that means, and that's where the comparison becomes quite interesting, in 2020 with the pandemic, they never suspended fundamental rights in order to say, okay, to justify governmental measures. They did declare a state of public health emergencies, but they did not rely on this exceptional measure of section 33 that they relied upon the year before for something else. So even though there is some kind of allergy, should I say, a political allergy to basically suspend it in the context right now, because democracy matters. So the message, you can take it from the positive end of things and say, well, if the government, both provincial governments and federal governments, did not rely on section 33 so far for several months to suspend civil rights, is because of their awareness of the seriousness of doing so. Suspending constitutional rights in the context of freedom of religion, it's really, that's only focused on a few professions, teachers, judges, as I said, it's narrow. But if you suspend the rights of all citizens, as that any governmental measure would do in the context of pandemic like COVID-19, the impact is broader. It's more serious. Every citizen would be directly, not saying they would not be indirectly affected by the other one, but would be directly impacted by the measure. So that may explain why the government did not decide to rely on section 33 of the Charter of Rights, which would have justified basically their suspension of fundamental rights in Canada. So as I said earlier, so there's one way, which is something else with respect to Section 1, and I will finish the lecture on this thing here. But even though the government would have relied on the Emergencies Act, the one I discussed earlier, and basically giving them freedom of deciding and suspending rights and taking governmental measures that would basically go against fundamental rights, there is still a judicial scrutiny. The courts, for every single governmental measure, even though the government relies on the Emergencies Act, Section 1, the section showing in the slide right now, is not suspended. So even though there's a suspension of rights, the courts still have power. So talking about checks and balances, even if the government of Canada would have relied on the Emergencies Act, it doesn't mean that it's a freelance to government to do whatever they want. No, there's still the examination of the courts. One difference well, it's not a difference, but courts have been, I was going to talk about the Supreme Court of Canada, but the Supreme Court of Canada suspended their activity for the most part, for the most part, but let's keep it at that. There are different ways to suspend constitutional rights. The one is Section 33, which suspends it for a period of 5 years. So after 5 years, the suspension of fundamental rights is not valid anymore, and there could be a breach. And second thing to remember about this, it's not often used. It's a matter of legitimacy towards the population. This section is not seen with great appreciation from Canadian citizens, because basically that directly affects democracy. The second thing is to say we will rely on the Emergencies Act to suspend fundamental rights, to give the freedom to the government to decide whatever measure they want to take. However, and this, just to summarize here, Section 1 is still applicable. So it's not a freelance or a free way or highway for the government to decide whatever they want. So we do have things in common. And just to go back, the right to life, the question of migrants, that's something I discussed in length in a different context. But in Canada, travels have been stopped too, right? So it did impact on incoming migrants, not migrants who are already in the territory of Canada, but who were impacted still by the limitation of freedom of movement. But Canada basically shut its borders, including with the United States. So that caused serious issues as well, but that's a different topic for another time. So thank you very much for your attention. I hope I was clear enough and that I didn't speak too fast. I have this tendency of speaking too fast when I'm intellectually interested, and I was very much interested and happy to be with you this morning. Thanks again.